The Firm, India's only show on corporate law, tax and audit matters.
Welcome back. You're watching The Firm. The Maggi case is an unprecedented case in more ways than one. It's the first such public face-off between the food standards regulator and a food company. It's led to the first nationwide ban against a popular food product. And now the government has filed its first such class action against a food company. This week, the government of India said it was suing Nestle on grounds of unfair trade practices and sale of defective goods. It has sought 284 crore rupees as penalty and another 355 crores as punitive damages for gross negligence, apathy and callousness. Is the government justified in taking such action against Nestle? Well, joining me today are Anand Desai of DSK Legal and Supreme Court Advocate Gopal Jain. Gentlemen, to both of you, a warm welcome. Anand, what do you make of this unprecedented class action suit?
So, Menaka, the Act does provide for such an action, and therefore the government is entitled under the Act to do so. I think currently the waters are muddied by the fact the Bombay High Court has stated currently that the processes required to be followed while testing, whilst banning, were not followed.
Correct.
And to that extent, I think it opens up a question whether this action is premature. There are fresh tests to be done. We have to wait for the results of those tests. But it is the first time this is being done, and from what we understand, there is no specific complaint filed for damages or compensation by any individual.
By individuals,
correct.
Yes,
so I don't know where the money is going to go at the end of the day. They say it's going to go into a fund if they do succeed.
Right.
But we have to wait and see.
But if you look at, like you pointed out, the Consumer Protection Act in itself and the section under which this suit has been filed, 12(1)D, does permit the central government or the state government to file a complaint at the National Consumer Disputes Redressal Commission, in its individual capacity or a representative of interests of the consumers in general. And it's not just this provision. As we were discussing earlier on, there are other several provisions in law that allow for the government to act representatively on behalf of citizens, residents, consumers.
So the Bhopal tragedy was a big one, where the government took a position that the poor people who had suffered did not have the ability to defend themselves or protect themselves in that case. And the government stepped in. I think that's a bit different because I don't know which consumer today is actually saying I suffered because of this and has linked the product to any specific damage for which he's claiming money.
Right.
So it's a little different to Bhopal.
No, not little, very different to Gopal. Gopal, would you say that the government is well within its right if it thought that a food product could be damaging to consumers or has been damaging to consumers, that it could file a class action suit, unprecedented as it may be, of this nature at the National Consumer Dispute Redressal Commission?
So, Menaka, I think we should look at it in two ways. We have to first see the context and the timing, and then obviously the power of the government under the Act. Now, the context becomes important because there is a regulator, and it's his job really to look at whether a food company is following the prescribed norms or standards, and he had issued a ban order which was the subject matter of a challenge. Coincidentally, the order came about the same time when the complaint was filed, and the order has said that the product must go back to 3 laboratories for fresh testing. So while this issue is pending between the regulator and the food company, the government has filed this case also asking for damages. Now, in order to establish damages, you first have to prove that there was injury, and in fact there was unfair trade practice or a defective goods. That still is under consideration. So in that sense, I think they've jumped the gun. But certainly the fact that the Act provides that the government can act in representative capacity is an important safeguard. It's good to have government being taking up class actions, but I suppose, they've really rushed into this one.
All right, so I want to try and break this up into two baskets. First, I want to talk about the mechanics of how such a class action would operate, and then we'll come to the Bombay High Court order and the implications of that on this class action suit. On the mechanics of the class action, the most interesting bit is the damages amount that the government has sought. As I said right up front, 284 crores in damages, which apparently represents, according to a PTI report, 10% of Maggi's annual sales, and then the remaining 355 crores as punitive damages, which again in the PTI report is explained as 30% of the company's profit from the product. How would you understand these amounts, Gopal? Is there any precedent, previous cases that help us understand how to arrive at amounts that could be asked for in such a class action suit?
Well, usually damages are always something which is adjudicated by a court and which requires evidence to show that let's say a defective product caused material injury and its impact. What they've obviously done is they've taken a very easy yardstick, which is to take its revenue figures as well as you said, profits from the sale of this, and treated that to be a measure of damages in the action from what you mentioned. But ultimately, in India, it is always for courts on the basis of evidence to be able to arrive at the correct number before they award damages.
Okay, how do you look at this? Because, in the Consumer Protection Act, Anand, it says the district forum shall have the power to grant punitive damages in such circumstances as it deems fit.
So I think there are two parts, and as has been said by the Supreme Court in one other case, they've said that there should be a recompense and there could be a sort of disincentive for the company in future to take such a position.
Correct.
So two parts to it, and possibly that's why they've done it. We haven't seen the complaint, obviously, so we don't know the details, but that possibly is the way they've looked at it.
But is there any guideline, is there any way, any previous case by which we could measure whether these are the right amounts as a percentage of sale or as a percentage of profit, for the damages, for a government to claim, or for anybody in a class action to claim in this country?
The principle, as Gopal said, is you have to prove damages. That's a fundamental principle of damages anywhere. But again, punitive damages can be given in a fit case by the courts as a...
But if there hasn't been any injury, at least there hasn't been any complaint, illness or death as a result of Maggi consumption that we know of publicly, right? So how do you then justify damages? You may justify penalty because the product did not meet your standards. But how do you then justify damages?
That's a big question mark as to how they're going to do it, and I don't know.
Okay, one more question on the mechanics of how this will work. Now, the PTI report seems to indicate that if the government were to win and get that damages amount, then the penalty and the damages, or at least the damages, would go towards the consumer welfare front. If you look at the Consumer Protection Act, it says very clearly that, such damages or such sum as determined by the district forum, should not be less than 5% of the value of such defective goods sold or service provided, and that the amount so obtained shall be credited in favor of such person, that is the affected person, and utilized in such manner as may be prescribed. Now, how do the two sit together? The government claims damages. Is it going to return it to all Maggi consumers in the country? Is it going to go towards a consumer welfare fund? And if it goes towards a welfare fund, is that in keeping with what the Act allows or provides for?
So, as you rightly said, recompense really is for affected persons. So far, we don't have the class or category of affected persons before the National Commission. Now, from what the PTI report seems to suggest, government may have said in its complaint that if you award any compensation, it can go to this fund. Presumably, the fund then, would look at this aspect of it, which is if affected persons do come. But all this has to be really carefully examined because it really seems to be a case of going to court and sending out a message that the government is taking on the food companies and the government is going to act in consumer interest. But clearly it's not well thought out in terms of legal principles which you mentioned, whether it's fully in consonance with the spirit of the Act and how it will actually pan out.
I think the other challenge here is going to be that the defective products have to be proved to be defective across years, batches, production units, etc. also to my mind. If the government is asking for this kind of relief, I imagine they'll also have to show this has been going on for some time, because you can't just throw a number up and say now pay. Okay,
in which case then I do want to come to what the Bombay High Court order has said, because that's really the final point that I want to make. And the order has ripped into the FSSAI, especially the processes of testing and therefore everything that took place before the ban order was passed. And let me quote from what the Bombay High Court has said. It said, in our view, there is something fundamentally wrong in the approach of the Food Authority and in the interpretation which is sought to be given by it to several provisions of the Act. It then says the ban order on Maggi has been passed in an arbitrary manner. There is lack of transparency. It is unreasonable. It was passed in utter violation of principles of natural justice. Then it says the samples of the product have not been analyzed as per the mandatory provision. The procedure was not fair and transparent. And finally, this is the most damning comment, Anand. It says, in fact, the entire sequence that culminating in the imposition of the ban order by the CEO of the FSSAI shows that there is something more than what meets the eye. How is the National Consumer Dispute Redressal Commission going to look at the Bombay High Court order and then look at this case? What weight will the order have?
So I think the order is not final, in the sense that Supreme Court is still there in case the government goes to Supreme Court, and I believe they will, is what I've been reading.
Sure.
That's one part. So it is not a final order in that sense. Having said that, given the findings of the Bombay High Court, I think it will be difficult with these findings to sustain this action they filed. So in a sense, it's premature, having jumped the gun. without having complaints from consumers, without having findings of the court, I think they have jumped the guns. We have to wait and see what the findings now are of the 3 laboratories. If that helps them, they may use that to support the action. If it doesn't help them, I think they fall flat.
Yeah. Gopal, you know, to undertake this kind of unprecedented action, and maybe I'm asking you to repeat yourself, but hasn't the government bitten off more than it can chew at this point in time? Yes, maybe you want to defend consumer rights in this country. Yes, maybe you want to send a message out by taking a large multinational to task. But when your own processes are so flawed, as the Bombay High Court has pointed out, you ought to be fixing what's wrong in your own house first before going after companies.
Exactly. You know, this required unprecedented thinking, out-of-the-box thinking and preparation and planning, which is to have outstanding laboratories, world-class laboratories, very well-defined norms and parameters, and that's where the government and the authority could have played a proactive role. Merely by going to court, as you said, you sometimes bitten off more than you can chew, because if these laboratories were to give a clean chit, then, you know, that's really egg on the face of that complaint which has been filed. And it also sends out such mixed signals to consumers in whose interest ostensibly the case has been filed. So I think what it really requires is for a correct framework to be put in place which adequately addresses it, as the Bombay High Court has said, strengthen the authority, give it experts, lay down world-class standards, and then ensure effective implementation. Fighting a case or filing a case in this case, according to me, was not the right way forward.
These 3 laboratories are going to be under immense pressure. And you know exactly what I mean by that question. Because if there is excess lead in this Maggi product, then Nestle's most popular product dies virtually, right? But if there isn't, the government ends up with egg on its face.
Seriously. Very seriously. Absolutely.
Right?
And I think another question is going to be, if one decides that it's contaminated or it's got excess lead and the other 2 do not, another question arises now, where do we go from here?
All right, so this is round 1 in a protracted battle. Gentlemen, thank you very much for joining us today to talk us through this. And on that note, we're going to wrap it up here on The Firm. Thank you very much for watching. We'll be back next week.